Hello everyone, welcome back to my channel. It's exciting to have you all back here. Today we are going to learn about how to make a will. Number one, if you want to make a will, the best advice I'll give you is that please go see a lawyer. It will be best to look for a lawyer to help you state exactly what your intentions are so that it will not lead to other troubles when you are no more. And then number two, advice that I give you, that if you can't make a will by going to a private lawyer and you don't have enough money to contract a lawyer to do this for you and you are within Ghana, the best advice I can give to you is that please go to any legal aid commission office. They will take you through the test to make sure you actually meet the requirements. Then if you fit that requirement, you'll be given a lawyer and the lawyer will assist you to make a will to cover any property that you have, so that one day when you are not here, there'll be no mess behind you. Now, if after all this advice that I have given you, you still want to make a will, there are two types of wills that you can make in Ghana. There is what we call the insamansew or the oral one, and then we have the written one. If you want to make that insamansew, your best shot is to have at least 2 witnesses. It means you can have about 4 or 5 witnesses, or you can just have 2 witnesses, and then make sure that at the time that you are making the will, you have a sound mind, and then you know all the properties that you want to give to whoever, the names of the people, the full names, because maybe some people may have the same names in your family. State it and say it to the witnesses, and then that would meet the requirement of a valid will in Ghana. If you're not going to make the insamans, you're going to have a written one because of all the challenges that may come with insamans. Please take note of the following. Make sure you have 2 witnesses. Make sure that at the time that you're making the will, you have sound mind. You don't have any mental impairment or mental incapacities. You know all the properties that you want to give to who and which person or what organization. And then you have the description of the properties proper. Yes. If you have this, you should also make sure that you have 2 people that we call the executors. The executors are people who will take charge of the will upon your death and make sure that everybody gets what they are supposed to get. Right, so those executors are people who will pay all your funeral debts and all the debts that you leave behind, and make sure that they administer your property by giving this to whoever you actually gave it to under the will. Right, so at the point that you are writing, we should make sure that nobody is forcing you, there is no duress, nobody is influencing you to make the will at the time that you are making it. You're making it out of your own free will. That is very, very important. Then if you are done with this, then what you have to know is that it can be written. You are good if you type this, because you can make corrections and all of that. If you type this, the best thing is that please date the will, so that when you are no longer there, we will know at what particular time that you made that will. Whatever you are writing, write it in paragraphs and say that number 1, I give this to Amma and Kofi. I give this to Amma and Kofi. If you want them to share it equal, you can state it. If you want Amma and Kofi to share it 30%, 70%, you can also state as well. Be mindful that if there are other wills that you have made before and you want to invalidate that other will, you have to state expressly that today I have made this will. I want this will to be my final and last will, and so it should take precedence over all the other wills that have been made. Take note. You have to state that. When you don't want to invalidate the earlier wills, then it means that upon your death, if we see 2 wills, then we'll be comparing which one was first, which one was last. Then we'll use, okay, since he made this one first and last, then the last one, if he gave the house to Kwesi in the last one, and then in the first one he gave the house to Amma, then we will use the last one. So if you don't want that comparison, and when you're making the will, the last, so make sure you make the proper introduction that you want that to be your last will, and you want all other wills which have been made before that date to be invalidated or to be void. So after listing everything this property should be given to who and what, after doing all of that, make sure that you write there's a particular portion in case that you make any property before your death which is not captured in the will. State who and who should have it. Right? Yes. So that in case you make the will in 2019 and by God's grace you die in 2040, but you're not able to capture something, that one will also be taken care of under your will. It is very, very helpful. Then after doing all of that, you have to sign. And then before you sign, there's something that you have to take note of. Before you sign, you should have your 2 witnesses there. Your 2 witnesses should see you signing the will. If your 2 witnesses should see you sign the will at the same time. So if you are in your room and you're about to sign, you want Kwejo and Nama to look at you, call Kwejo and Nama. Kwejo and Nama, come and see me signing this document. They don't have to know that it is your will, but they have to see you signing that document. And then after you have signed, Kwejo and Nama should be able to also sign and say, okay, we were witnesses that this man signed this particular document. Take notes. So that's one option. Another option is that you can sign, but you have to call Kwesi and Nama to come there at the same time to come and observe that, okay, please come and identify my signature at the same time. After that, Kwesi and Nama should also write that, oh, we were there and we saw this person signing a particular document. Then you meet the requirements. In case the person that you're preparing the will for is illiterate or blind, you have to be able to write that you mentioned the name of the person who read it. So this particular person read and explained the contents of the will to this blind or illiterate person, and then after that he made the mark. If it's a blind person, then you helped him to make his mark or sign on the document. That is the only time that it will be said that he was the one who made the will, because he understood the content of the will. In case that you are done making the will, make sure that you don't write anything else below your signature. Take note. Don't share any of the properties after you have signed and you and your witnesses have signed. If you do that, all the things that you shared under your signature will be deemed to be invalid or void. So make sure that you only sign after you have shared all the properties in the paragraphs that you have talked about above. Right? If someone is going to be a witness for you, make sure that that person is not inheriting under your will. So it means that if you are giving a house to, say, Sandra, make sure that Sandra does not come to sign as a witness under your will, because the law says you need 2 witnesses. If one of the witnesses sign under your will, then it means that whatever you gave to that person, the law will not give it to the person. Yes. So make sure that the witnesses are not people who are inheriting under your will. If you are lucky and the witnesses are more than 3 or more than 2, then maybe the 3rd person is inheriting something under your will. The law will excuse that. But make sure that the 2 people who are witnesses for your will are not beneficiaries or are not getting anything under your will. Because if you do it, those people are not going to get anything under your will. Yes, so I think basically that's it about making a will on your own. But then some people ask that, oh, can my father take my name out of his will? Yes, if you are more than 18 years, your father does not have any obligation to keep you under his will. But if you are lucky and you are less than 18 years and your father does not give you anything under his will, and then during the time that he was alive too, he didn't make any reasonable provision for you, then after his death, you can go to court and say that my father didn't make any provision for me, and so the court should give you something under his will. If you are done making a will and you have got your witnesses to sign and all of that, just seal it, have about 2 or 3 copies for yourself, go to any court nearby. Either it's a high court closer, that is the best option. Go to the high court and tell them that you have a will and you want to deposit with them. There will be an amount of money that will be charged, which is less than 200 cedis to the best of my knowledge. And go there with your passport picture, if there are any other requirements they may ask of you. And please, they'll keep your copy there, and then you also have your copy. And then, hey, in case anybody dies and you want to be sure if there's a will or not, please write a letter to any court nearby or any high court nearby and ask, please, this is the name of so and so person. Did the person make a will? They will answer you and reply back to you. They will search through their docket or their document and find out if whoever you're asking of made a will. If someone made a will, it doesn't mean that immediately they made a will, that whatever they gave to you is yours. No, the executors will have to go to court and get authority or permission from the court to share the properties. And then when they share it, they are not sharing it in any other manner, but they are sharing it in accordance to how the person who died stated in the will. After they do that, then they will prepare a document which you call the vesting assent. That will be your title document for the property which was given to you under the will. So in case someone gave you a house under a will, don't go using the will to say this will shows that the property is mine, so it is mine. No, make sure you tell the executors to do the right thing and go to court and get the proper documents so that they can give it to you, because that will be the right authority you can use to maybe sell or even rent the house in a house that we are talking about. And hey, in case somebody has died and you have seen a will close by, please don't hesitate. Immediately take the will to the nearest court or the nearest high court. The law says that if you don't do this within 14 days, you are committing a crime and you can be punished under our law. The court will later call the people who are involved so that they will read their will and everybody will get to know what they are supposed to get under the will. Okay, some people also ask that, okay, so if I'm married to someone, I'm the husband or the wife, can my wife or my husband refuse to give me anything under his or her will? The law says that yes, it's possible, he can. But then, if your husband or your wife does not make any reasonable provision for you whilst he or she is alive, and then he doesn't make any provision for you to under his will, then upon the person's death, you can apply to the court and say that this person has the right to make a will. But then at the point that he died, he didn't make any provision for me, and then the will too, he didn't make any provision for me. Then the courts can actually make some changes in the will and take some properties and give to you as a wife or as a husband. Same can be done for parents as well. Remember that for children, you must be less than 18 years. Some people also ask that, okay, if I divorced my husband or my wife, and the person made a will and put my name in it before we divorced, and he didn't change the will before he died, can I still inherit under his will? No, the law says that immediately you divorce the person, if the person made any gift to you under his will, the law says that particular gift made to you under the will no longer be valid, unless that there were some special descriptions and reasons why he gave for giving you that property. And so it means that just because he said to my wife Tina does not mean that even when I divorce you, you have to get that property. No. But then if he says, oh, to my wife Tina, for all the struggles and how we did this together, all those special arrangements will make it look like this one was supposed to be given to you even if you guys divorce or not. So please take note of that. If there's anyone telling you that, oh, I've made provision under the will for you, so even after divorce, don't come for the property and we'll give you a part under my will, please be careful with that. It may not be all correct under the law, because immediately you divorce, you stand a chance of losing the thing that has been given to you under your ex-wife or ex-husband's will. And before we end, make sure that anything that you are giving under your will to anybody is your personal property. If it is not your personal property, then you can't give it to someone. You can't give family property to your children. It is your personal property. Things that you will get now and things that you may get later. I know there'll be several questions. The video cannot be this longer, so please let me know your questions. Put them in the question box or comment section. And if you have not subscribed, please be kind and subscribe, and stay tuned for more, because we are here to learn. Until the next video, please have a very good time. Bye.